Cohen. Okay, the committee welcomes representatives from the Commonwealth Bank. Thank you for attending today's hearings. For the Hansard record, would you please state your name and the capacity in which you appear today?
Thank you, Chairman. David Cohen, Group Executive and Group General Counsel of Commonwealth Bank.
And Robert Luca, Managing Director of Bankwest.
Okay, the committee has received your submission number 48 and subsequent answers to questions on notice. Would you like to make a short opening statement before the committee proceeds to questions?
Thank you, Chairman. We welcome the opportunity to appear before the committee today. Since this inquiry was referred to the committee 10 months ago, we have provided a written submission. We've also responded to other submissions that the committee has received. We've appeared before the committee in December for over 2 hours. We've answered over 50 questions on notice. We reviewed in detail 36 customer submissions relating to Bankwest, and we provided comprehensive responses, including timelines, to 8 specific customer cases of particular interest to the committee. We have made available hundreds of pages of content to committee members, and I'd just like to take this opportunity to summarise what we have provided. There are broadly 3 questions to consider in relation to Commonwealth Bank and Bankwest. First, is there any evidence of a conspiracy around the purchase of Bankwest? And did Commonwealth Bank have an incentive to impair loans to reduce the purchase price or gain some other benefit? The unequivocal answer to that is no. Commonwealth Bank could not reduce the purchase price payable to HBOS by impairing customer loans, and nor did it attempt to do so. Commonwealth Bank repaid all of the wholesale funding, and there was no clawback possible. There were no warranty claims in relation to impaired loans. There was no loan guarantee from the British government, as has been claimed. And there was no capital benefit from impairing loans, as has been claimed. Commonwealth Bank incurred more than $2 billion of losses on Bankwest commercial loans and had no recourse to other parties for those losses. They were borne by Commonwealth Bank shareholders. The conspiracy theory is simply not true. Secondly, putting aside the conspiracy theory and the lack of any motivation to do so, did Bankwest take action against customers who were meeting the obligations of their loans? Clearly, the answer again is no. We've examined 36 of the submissions provided to the committee. Of those 36, the customer was in monetary default in 33 cases. Of the remaining 3, in one case there was no monetary default at all, and therefore no enforcement action was taken. In the second case, the customer appointed a voluntary administrator itself, not Commonwealth Bank or Bankwest. And in the third case, the customer invited Bankwest to appoint a receiver because of its financial difficulties. So thirdly, accepting that there was no conspiracy and the customers were failing to meet obligations to Bankwest, did Bankwest act too quickly? Or did it fail to adequately work with customers? Again, the answer is no. We have examined 28 submissions related to Bankwest where a receiver was appointed. The average number of days between the first default evident and the appointment of receivers was 539. That's 539 days, nearly 18 months. The median number of those days was 397. So if I can just summarise for you, around 40 Bankwest customers have provided submissions out of around 26,000 commercial customers. Around 12 CBA customers out of 126,000 commercial customers have provided submissions. Some individuals continue to claim Bankwest appointed receivers to more than 1,000 cases and constructively impaired $8 billion of loans. These claims are simply fictitious. There is no doubt that a business in financial hardship is stressful for a customer. If the inquiry produces evidence of any customer being mistreated or any new information about their cases, we are always willing to review our actions, as we've previously made clear. However, some customers who have appeared before the committee have simply not given an accurate picture of events, and we cannot allow these statements to stand without correction. We have provided clear factual evidence to refute these inaccurate claims. Some customers who appeared before the committee claimed that their loan was put into default despite never missing a repayment. That is just not true. Of the 8 customers the committee identified as being of most interest, 7 ended in receivership. Every one of those 7 missed repayments or failed to repay their loan when it expired. There's been no evidence produced to explain why Commonwealth Bank or Bankwest would take action against a customer who we believed had the capacity to repay their loan. The interests of the bank and our customers are aligned. That is, the best outcome is that their businesses flourish and they repay their loans. Instead, in these 7 cases where a receiver was appointed, Commonwealth Bank wrote off close to $190 million. While we worked with each of these customers for a significant period of time in an attempt to improve their circumstances, in all but one of those cases, unfortunately, this was not possible, and the actions taken were an unfortunate last resort. Thank you, Chairman, for the opportunity to give the opening statement, and we look forward to answering your questions.
Thank you, Mr. Cohen, for your opening statement and for the effort you have gone to answer a range of questions on notice. May not surprise you that just as you maintain that some of the facts that have been put forward in submissions are not accurate, we also hear extensively from consumers that some of the responses you've provided are not accurate. We may well engage with you further in terms of understanding just how transparent you're happy to be with some of the answers you've provided to us to allow consumers to put forward any evidence they have to refute some of the positions you've taken.
Very happy to, Chairman.
But we thank you for the work you have put in. I take it you're aware of the changes that are proposed to take effect on the 12th of November this year in terms of extending unfair contract provisions to small business?
Yes, I am.
You're familiar with ASIC's guidance material?
Yes, I am.
Could you talk to the committee about what processes the Commonwealth has in play at the moment to review your standard contracts to meet the intent of ASIC's worked examples?
Yes.
I think the most pertinent one is probably their 3rd worked example, which says that under the current construct, where the bank essentially has a unilateral right to vary a range of terms and conditions, that to make it a fair contract, then a small business would be needed to give an exit clause to exit without penalty in an appropriate time frame from that loan. Can you just talk about processes and where you think that will end up in terms of extending that to small business?
Certainly. I think the first point to make, Chairman, is that since the legislation was first mooted and then passed, we've had a project underway across the group to review documentation to ensure that we do comply with the legislation from the 12th of November. That process is underway. It involves a cross-team project, so it involves business people, legal people, risk and compliance people. And we're going through every contract systematically, as we did when the unfair contracts regime was introduced at a consumer level a couple of years ago. We're following pretty much the same process as we did then. And that project's well underway. One point I would make is that, as you would be aware, the new regime as it applies to small business contracts does have a $300,000 or $1 million threshold, which in cases such as the ones we've been considering with the committee, unfortunately doesn't necessarily help much because it doesn't catch those cases. So there is, I suppose, an issue in that those thresholds will catch certain but not many, or sorry, not all, of the relevant sort of business loan contracts that we've been talking about.
So would you be supportive of raising that limit?
Well, I think, Chairman, our suggestion would be that let's see what this first manifestation is and how it works, and see what the experience is for a short period before people consider extending it again. It is a new regime, and I think it's sensible for us to see how that new regime is going to operate for a period before making judgments as to whether it ought to be extended. So
if it's within the bank's gift to exercise your contractual arrangements with customers as you determine, given that ASIC have basically indicated that they won't seek to determine what is a fair contract or not, they'd leave that to the courts. Given what you've just said about your desire to work with customers, would the Commonwealth Bank look to unilaterally and voluntarily increase the monetary limit upon which you apply the same process of providing fair contract terms and provisions to small business?
So I think our position, Chairman, is as stated, namely we want to work within the regime as it exists at the moment to actually seed it first, to see how it works out, both from us, from our point of view and from a customer's point of view. Then I think we can make more sensible decisions as to whether it ought to be extended voluntarily or mandatorily.
Mm-hmm. Could I take you to the issue of responsible lending practice? We have at least one submission that in some detail talks about a loan the Commonwealth Bank provided to a small business where there is email traffic to indicate that the bank's assessment of the security held by this person and their business, including their personal assets, was comfortable. I think the wording was it gave a degree of comfort, but they recognised that their ability to repay the loan was questionable, and yet the bank made the loan. Why do you do that?
Well, that's not the general practice. So we apply loan serviceability tests when assessing an application for a loan. Both our business people and our risk teams who assess applications are trained in serviceability calculations because it makes no sense from our point of view, nor the customer's point of view, to enter into a loan where the customer is known not to be able to service a loan. That makes no commercial sense at all.
Then why would a line manager within your business and the various people who sign off on the supervisory levels of approval have approved that loan?
Which loan are you specifically referring to?
It was one in Tasmania to a small business.
If you can give me a customer name, I can give you details potentially.
Well, we can do that, but I'm looking here more at a governance compliance regime within the Commonwealth. If that's not in the business's interest and it's not in the consumer's interest, how would that have slipped through your system?
Well, it should not have, and I can't give you the specifics because I don't know the customer name. If you tell me the customer name, I might be able to give you the specifics. At a general level, which I think is where you're pitching the question, our systems and our processes are designed for that situation not to arise. So if it did arise, then we would need to look into that.
So in this case, it was looked into. It actually got lodged with FOS, and FOS found that there was maladministration within the bank over that loan. What action was taken to individuals within the bank who were part of that process?
Well, Chairman, I've asked you 3 times now for the name of the customer and you won't tell me, so it's very hard for
well,
me to answer.
I'm happy to tell you, but not in public session.
Okay, well, I'm happy to answer you not in public session as well once I know the name.
Okay, so let's take it back to a general level then. In a situation where FOS found that there'd been maladministration, regardless of who the consumer was, what would your expectation be about action the bank would take?
We would look, so normally if there was proven, in this case it sounds like proven maladministration, at least as found by FOS, normally in those circumstances we would look at the individual concerned and their conduct and look at their performance on the individual loan. If we found that they failed to meet their obligations, both in terms of their key performance indicators and their risk requirements, then a range of sanctions could be applied. And it would depend on the individual case. Those range of sanctions could be, for example, a training, counselling, in other words, go and do more training. It could go to something more significant, such as a reduction of pay, of a bonus, or if it was a very serious case, it could go to termination of employment.
Yeah, but that would be a breach that would be reported to ASIC?
Not necessarily, Chairman, no, because the breach reporting process, again, depending on which area we're talking about, breach reporting is often done on the basis of significant breaches. So an individual case might not amount to a significant breach. So as you're probably aware, in the Corporations Act, there are various tests for determining when a breach is significant. It's unlikely that a single individual case, unless it was something that was systemic or evidence of systemic issue, would amount to a reportable breach.
In the correspondence that FOS sends out to people who make a complaint through that system, there's an indication that if the bank is found, or the lending institution is found to be at fault, that FOS would seek to restore the consumer to the position they would have been at prior to that loan, or if that loan had not been made. Yes. Do you support that as a general principle?
Yes, generally we do, and that is the situation that we find ourselves in those cases where FOS does make a determination in favour of the customer. The intention is, for example, if it was maladministration or mislending, the intention would be to reduce the loan amount by the amount of excessive lending, if I can call it that, to put the customer, and then repay interest that was paid on that excessive amount and fees that was paid on that excessive amount, so that the customer is in a position whereby they were effectively lent what they should have been lent.
If following the process with FOS, and again, generic question, FOS realised, because of new evidence that was presented, that their determination about the size of that excessive lending had been inappropriate, despite the fact they'd made a determination, would the bank seek to actively work with the consumer to redress that situation, or would you rest on the finding of FOS and allow it to sit at that point?
So from our point of view, Chairman, if it would be unusual for us to simply rely on the strict finding of FOS one step before FOS received updated information. From our perspective, we try to ensure that we give excellent service to customers, and that doesn't just mean in the lead-up to entering into a transaction, also means afterwards. So on its merits, at a general level, on its merits, if there was subsequent indications that lending had been excessive over and above the extent previously determined by FOS, and that is something we would look at seriously.
And would you require FOS to make a new determination, or would you be happy to engage with clients?
Generally speaking, no, we would not insist on going through another FOS process. I think in those circumstances, one has to be both practical and understanding of the customer situation. If we have had information brought to us that suggests that the lending was more than or more excessive than the FOS determination, and that is not a fanciful or lightly made allegation that is backed up with some evidence, and that is something that we would take seriously, and we would not require that it go back to FOS for yet another round.
It has been put to the committee that we should consider a commercial arbitration option to be built into contracts. What would the bank's view be if that became a standard part of contracts for lending above a certain threshold? So we're generally talking here with a larger company, not a corporation, but an SME.
Yes.
That commercial arbitration should be something that is a standard way of resolving these issues. So essentially a FOS, but built into the contract.
But built into the contract rather than it being through a body or an agency as such. Well, it's interesting. Over the years, commercial arbitration has evolved from being quite an expedient alternative dispute resolution mechanism, and it has developed to the point where actually it is not much more expedient these days than court proceedings, unfortunately. It is still more expedient. It does not suffer from quite the same resource constraints that the court system often suffers under. However, it has evolved somewhat, and I think somewhat disadvantageously for the sorts of purposes that you're talking about. It has evolved somewhat from being quite an expedient alternative way of resolving disputes into becoming quite a technical and in some respects legalistic way of resolving disputes. So my only caution would be to say that whilst in the past it had quite an attractive element to it, these days commercial arbitration itself is quite a lengthy, time-consuming and legalistic process. Perhaps to just take your question, though, away from commercial arbitration per se, but I think looking at some alternative dispute mechanism. My response to that would be, in the case of small business, that might be an appropriate position to take. I imagine that, however, in the case of medium to large business, we tend to operate on the basis that those businesses are able to pursue their legal rights if the parties are unable to come to an agreement.
As long as they're not wound up or bankrupted.
Correct. Yes.
Which appears to be the case for many of the people who've been affected by the sort of inquiry that we're looking into. Can I take you to the issue of remuneration? The new CEO of one of your competitors has recently made some comments about reviewing the remuneration structures of staff because of the potential for it to adversely impact on culture and practice. We've seen the head of ASIC make comment on this, and a range of people identifying that the culture within a bank or within any institution is as important as the conduct of any individual person who may be labelled a bad apple. When it comes to lending practice, we have had concerns raised with the committee about remuneration structures, and I notice in your answers to questions on notice that you gave quite a detailed breakdown about essentially the gate that people have to pass in terms of their ethical conduct before they're even eligible for bonuses. Can you describe to us what your compliance checking process is to evaluate their conduct so that there is some level of assurance that it's not just a box-ticking exercise, but that their conduct is indeed being scrutinised to stop the kind of behaviour that will ultimately disadvantage a customer who is given a loan, as we saw in this case in Tasmania, that they couldn't service or was on the basis of a valuation that was very optimistic?
Yes.
Counsel, for me to respond?
Yes, absolutely.
Chairman, I'm happy to respond to that question. Just to give you a little bit of practical how it works from a day-to-day basis. From the point of the origination, when the commercial lenders put through a submission to provide financing to a business, depending on delegations and authorities of who can actually sign off and approve that, that's gone through its process. Typically, they're risk officers. Once the loan has been approved, then there is ongoing monitoring of the performance of the loan. So typically there's things like arrears management. So if the loan goes in excess of its limits, goes overdrawn, that appears on a report. On a monthly basis, the business bankers have a scorecard assessed against their performance, which looks at a number of typical metrics. That's reviewed by line 2 in our case, which we call risk management, which is independent from the commercial lenders. So when it comes to the performance remuneration process at 30 June, when we assess the individual commercial lenders, there is input from detailed reviews from the risk officers on the performance of the loans in the portfolio to give managers and senior management's comfort that they've operated within the terms and conditions from a compliance perspective.
So I'm not filled with comfort as I read the Weekend Australian, where I see that your compliance checks within the organisation around things like acquisition of IT involving lines of management who disregarded concerns that were raised because of, in this case, the potential for them to seek illegal benefit, and the systems of compliance and checks obviously broke down and those bribes occurred. But what we've heard also is that remuneration packages relate not just to individuals but also the groups that they work within, and so clearly there is an incentive at those levels of sign-off within the group for the group as a whole to do well. Pressure can be applied, as it was in the case of the IT acquisition. So my question then extends to if in the area of financial advice, we are seeking to raise the ethical and educational and professional standards of advisors, and under things like FOFA, make them individually accountable for statements of advice. How would the bank respond to a requirement to lift the individual accountability of the people who sign off on a small business loan, where it's going to potentially impact upon not only the livelihood but the families, the family home, equally as significant as the financial advice somebody might give around retirement savings? If the requirement were to come in so individual accountability became a feature of the lending system in Australia, what would be the unintended consequences? What would be the benefits of moving down that path?
It's difficult to say what all of those unintended consequences would be, Chairman. I think the one issue that we would have to consider, I think the industry, not just us as an individual institution, would have to consider is, does that make the industry sufficiently unattractive for people to join? Does that mean that you don't get the best quality of people? Does that mean that you end up with second-level quality people? I think there are ways around that, personally. But that would be one issue that would be considered. I think the overall notion of having individuals accountable, whilst it has some attraction, I think it doesn't necessarily deal with what some of the regulators have been talking about and others in the industry, and that is the absolute importance of having the right culture in an organisation as a whole. It needs to be a culture that is organic. I think having that culture imposed purely by regulation only works to a degree. So that's not a reason to say it should not come in at all, but it should only be one of a number of measures.
So have you organically reached out, for example, to the gentleman who was the whistleblower, who objected to things like this IT contract, to make some remedy to him? Because what that speaks of to the consumer and the broader public and to all the employees in the Commonwealth is that the culture in the bank still does not support individuals who wish to do the right thing, even if it is seen to go against the interests or the wishes of somebody in the line of management.
So, Chairman, I have actually met with that individual. I met with him in June of last year and in August of last year, when it became apparent to us that he had raised issues with his direct manager in December 2013, just before the IT contract in question was signed. It became known to me in June that he had raised issues, and this is June last year. And the reason it became known to me is because once the police laid charges against the two former executives and the issue was out in the public domain, that former employee came forward to say, I raised issues back in December 2013 with my direct manager, and by the way, I was then made redundant several months later. So I was sufficiently concerned by that. Once I received that notice, I met with him in June 30 to hear from him exactly what the circumstances were of him raising the issues, firstly, and secondly, to hear his concerns about being made redundant. He was concerned that he had been made redundant because he had raised issues. So I then investigated it with a couple of members of my legal team. I went into, personally, quite a lot of detail around the restructure of his team. What happened in January 2014, so about a month after he had raised issues, was his entire team in his division was restructured, and I think 7 executive manager positions were reduced, I think, down to 5. Everyone had to apply for their position again. Everyone was scored on an individual basis, so I went into that in a lot of detail to look at his individual scoring on all of the criteria for the role against the criteria that's scored for every other candidate. And I then met with him in August of last year to take him through that and to explain to him my view, which was that I had looked at it as impartially as I could, together with one of my legal team members who's an expert in employment law, and that we had gone through the selection criteria in detail, we had gone through the scoring in detail, and in fact he had not measured up as well as some of the other candidates against the criteria.
You've used the word impartial there, Mr. Cohen. It's my understanding that the person who perhaps did that scoring was in fact one of the managers who this person had objected to the IT deal going through and who was subsequently jailed. Is that correct?
No, that's not right. So that's not right at all. So
it's as reported in the paper this weekend, so that's incorrect, isn't it?
So you should not believe everything you read in the papers. So I'll tell you the facts. I'll tell you the facts. So he raised his issues in late December, or mid-December actually, 2013 with his direct manager. His direct manager reported to one of the executives who we subsequently terminated in December 2014. The assessment of criteria and skills used to determine who would take roles was carried out by the person to whom he reported his concerns. So his direct manager carried out that assessment. The ex-employee did have an interview with one of the executives who was terminated and who's been charged, but it wasn't that executive who made the choice. It was his direct manager who made the choice.
Okay. The reason I'm labouring this point a little is I'm concerned to understand what has changed within the bank and its culture, in that if those kinds of concerns could be raised and dismissed by management over something as transparent as poor acquisition practice that puts the bank's money at risk, let alone the consumers, then somebody who is concerned about pressures within a business unit of the bank in terms of remuneration structures and lending practice who wishes to raise a concern, what confidence can the committee have or the public have that concerns they would raise would be dealt with in any more of a transparent or effective manner, given that, because of the group remuneration incentives, that people in the management stream may see that such a complaint could in fact impact their own personal bottom line and remuneration. What has changed in the last 2 years after that experience to make sure that people who wish to raise a concern are able to do that? Because I've met with people who have left the banking system because their concerns were not listened to over the corrupting influences of remuneration structure.
Yes, I understand. So if I can deal with that at two levels. Firstly, at the specific level, the issues raised by the former employee did not give any indication of the sort of criminality that's been alleged to exist now. He raised issues specifically on two fronts. One was that procedures around contracting, normal procedures around contracting had not been followed. So at the point he raised issues with the executive who was dismissed, he was concerned about a lack of legal review and a lack of due diligence review.
And Mr. Cohen, if you excuse me interrupting,
yes.
The very concern that we are raising around things like responsible lending and the corrupting influence of remuneration structures is that you've said they rely on adherence to a process and compliance with a process.
Yes.
And that's exactly what this person reported and was ignored for.
Yes, so what he raised was a number of process issues that concerned him. What has not been reported subsequently is that having raised the issues, he raised the issues around no legal review and due diligence quite early in the contracting process. Actually, what he didn't know, and what he hasn't subsequently revealed publicly, is that there were lawyers working on that transaction. In fact, there were external lawyers working on that transaction. He's never mentioned that, but that is a fact. There were actual processes going on around due diligence, bearing in mind that this was a relationship that we held with the IT provider since 2012. So this was not a new relationship. It was a relationship under which a contract existed for some time. He was not particularly close to that previous contract. So whilst there were processes in place, he was not necessarily aware of them.
And they weren't necessarily particularly effective either from a due diligence perspective, I might suggest, Mr. Cohen.
Well, actually, the Service Mesh, who was the provider of the software, have been doing so since 2012 quite successfully.
Do you frequently have $2.9 million worth of bribes paid as part of your normal process?
No, we don't. And in fact, this is what was, obviously, because it was criminal, as alleged, and because it was not happening above board, the due diligence around it would never have picked it up. The due diligence goes into the nature of the company we were contracting with. The bribes were not paid by the company we were contracting with.
I don't particularly wish to go down the rabbit hole of that contract. My point that I think I've made is that I have concerns about the ability of people within your system to report concerns and be listened to, and I'd be happy to take an answer on notice about what specifically has changed in terms of the reporting and ability of somebody essentially to whistleblow within the Commonwealth Bank around concerns in that structure. And I'm going to go to Senator
So, Chairman,
O'Neill.
if I could just say one thing in closing, therefore, on that point. We have considerably revamped over the last couple of years, but particularly in the last 12 months, our whistleblowing system. So we have a hotline, if I can call it that, or a reporting line called Speak Up. It's staffed by external contractor. It's not staffed by our internal people. It receives information either confidentially or with name attached as the staff member wishes. It then makes that external consultant then makes a determination as to what type of issue it is and therefore what sort of resource should be applied to investigate it. So whether it's a legal issue, an HR issue, a commercial issue or a fraud issue, for example. And then investigations are carried out. The enhanced system involves keeping the whistleblower informed, particularly obviously only if they're not an anonymous whistleblower, but keeping them informed along the way so that they, and that has been a weakness in the past, I think, of the process generally, is knowing how to deal with the whistleblower. So that has been enhanced considerably. There is also now an oversight committee comprised of 4 group executives of the bank, and I'm one of them, that oversees the complaints every quarter and looks at the progress of each complaint to make sure none are just left wallowing or stuck and are actioned, and also looks at the treatment of the whistleblower to make sure that they get the protections they deserve, and thirdly, looks at the consequences and how the consequences have been dealt with.
Thank you. Senator O'Neill.
Thank you. So my first question is that that gentleman who was the identifier of these practices quite early on, have you appointed him to one of those probity boards that you were just talking about then? Is he still looking for a job? He might be your man.
No, he's not any longer looking for a job. When I met him in June and August of last year, he was working for another financial institution, from memory. He expressed actually, how would I put it, he liked Commonwealth Bank. He said he would still like to work for Commonwealth Bank if there was an opportunity for him to do so. Whilst he was happy with his job at the stage, he was still happy with it. To come and join us if there was an opportunity to do so. We have not made an offer to him. The probity that I just described to you is an internal committee of group executives, so senior executives.
There are many more questions along that line that I'd like to go to in terms of culture, and I guess before I go to my questions, which are around valuers, investigative accountants and receivers, and also I want to talk to you a little bit about Basel 1 and 2, and I know that the other senators have questions. My questions this morning to the ANZ Bank were really about those cultural dimensions of behaviour that can't be actually measured with the sorts of processes I think we've just been hearing from you about, and the kind of leadership that's required to indicate that behaviour that goes beyond the pale won't be accepted. And I have to say that I appreciate how well prepared you are, Mr. Cohen, but the tone of the conversation that we consistently hear is not unsurprisingly defensive. That's your role, to be here and defend the bank. But I don't sense a shift in language use about conciliatory behaviour and more of an ethical discourse around customer relations. I don't quite hear that we're there yet, if I can just make that observation. Could I go to the valuers, investigative accountants and receivers? Where a bank does not appoint a receiver but proceeds to possess and sell off a property, what governs Commonwealth Bank's conduct in terms of using proper processes, in ensuring that the property is sold at market value in a manner that is agreed to and understood by the commercial loan holder as well as the bank officer?
So this is in circumstances, Senator, where a receiver has not been appointed, but where the bank itself sells the property?
Yes.
Okay. So that's known as mortgagee in possession,
yes,
as you probably know. There is a whole body of case law over several hundred years dealing with the obligations of a mortgagee in possession. There are also obligations under our conveyancing legislation dealing with that. So the legal obligations are very well known. I should say that it's probably in the vast minority of cases where the bank acts as mortgagee in possession. It's probably more common, not probably, definitely more common, for a receiver or other controller to exercise the power of sale and sell property. However, where a financial institution generally acts as a mortgagee in possession, actually sells the property, then it is subject to the common law and the statutory law duties around doing that.
And in terms of getting a valuation, because this is the evidence we've heard this morning, we've heard a range of evidence from different organisations that are responsible for the management of valuation, valuers in the country. What are the processes that the bank engages with in terms of getting a valuation that allow the loan holder to actually be part of the process of determining the terms on which that valuation is undertaken and receiving the valuation, and what's the relationship in terms of who pays for this?
Certainly. You may recall, Senator, that when we appeared before the committee in early December, as part of our opening statement, we made a suggestion around valuations because
You did.
I think, as we discussed then, the practice to date has not been to necessarily provide the customer with a copy of the valuation that the bank requires to be obtained.
Which is very different from what we heard from the ANZ. They were at quite a degree of pain today to make sure we understood this was a long-standing process for their part.
Well, I'm just talking at a general level here, not individual cases, but I didn't hear ANZ this morning.
Mm-hmm.
But that's why we made the suggestion in December that across the industry, the practice could change to one whereby if a valuation is obtained by a financial institution, then a copy of the valuation is provided to the customer. All the more so, as I think we discussed then, because the customer is paying for that valuation.
Has your practice changed?
Has our practice changed today? No, not yet.
You haven't implemented it voluntarily?
Not yet, Mr. Ruddock,
Okay.
no.
And so we find ourselves at a point where the customer is still paying for the valuation. They don't get to see it. So I would assume then that they are not a part of the terms that are decision-making around the terms that are given or the directions that are given to the valuer.
So you mean the instructions to the valuer,
Yes.
for example? So generally speaking, if it's a valuation that is obtained at the commencement of a loan relationship, the bank will instruct the valuer. Likewise, at the enforcement stage, if
Is there a standard form that you use for that, Mr. Cohen?
of the instructions.
Yeah, at the beginning.
Actually, I don't know the answer to that, Senator, whether it's a standard form. I don't know. We can find out for you and take it on notice.
But that would be good if you could provide us a copy, because one of the interesting things that seems to be emerging is the difference in the type of valuation that's acquired as the business is constructed, and significant change at a point further down the line when the business looks like it might be in distress, and there's a different set of instructions issued, which are extremely opaque to us at this point of time. Who makes the decisions around that? And from what you've said, certainly not. There's no consultation with the loan holder about those directions and change in directions to the valuer.
No, that's generally the case. And the only other thing I would add, Senator, is in December again, I think we suggested, therefore, that where appropriate, and we acknowledge that not all circumstances were appropriate, but where appropriate, the basis of valuation going in should be the same as the basis of valuation going out, where that can be done. Which I think gets to your point around standardisation of instructions.
And also a degree of transparency and understanding. One of the things that strikes me is how we've had to go through so many inquiries to get to the point where we now know as of today that there are different types of valuation. There's a market valuation, there's an asset valuation.
Yes.
Could you explain to me, fill out a little bit more information for me around, is it an asset valuation that you actually are getting when you seek to sell off a distressed property? Is that what you're actually asking for?
It depends on the circumstances, Senator, and it depends very much on whether the condition of the asset, the condition of the industry, the condition of the market. Generally speaking, and this is again at the generic level, generally speaking, a valuation will be sought which seeks to value the asset as it stands at that day.
So it's worth its investment value rather than its market value. Is that correct?
Well, the valuers apply their professional expertise and their professional standards in coming up with the value, but what we generally ask is for a valuer to tell us what the value of the asset is in the market, and in order to determine that, amongst other things, the valuers will look at comparable sales of similar properties in similar locations.
If I could just follow up on that, too.
Yeah.
I think we've heard the RICS organisation indicated that standard assumptions would be that, as part of those instructions would be that there would be a reasonable time given for marketing of the
Yes.
property. So that has to be one of the sort of presumptions. Are you aware that there may be some situations, say mortgagee in possession, where there is a truncated marketing period as part of your instructions?
So generally, Senator, truncated marketing periods are rare, and they usually arise only in fairly unique circumstances. So, for example, and about the only unique circumstance that I can give you straight off is, and Rob might be able to give more, but is where a market is rapidly declining, where there's clear evidence that a market is rapidly declining for that type of asset in that location. In those circumstances, it's not to the borrower or the bank's advantage to delay if it's felt that that market is going to continue falling rapidly.
But in that case, in many situations we've heard, you might disagree with this, but the borrower feels that it's not to their advantage to have to use the term, forced sale.
Yes, yeah, and we completely understand that. And actually, it's not to the bank's advantage either. for a property to be known to be sold as a forced sale or a fire sale by any stretch, because that only produces a lower, it tends to scare off bidders, and it tends to produce a lower price, which is not to anyone's advantage.
Could I ask, because we can't seem to get any clear line of sight over the valuers. You have a pretty big institution that uses valuers fairly frequently. Could you give us an indication of how many valuers you believe are out there?
Well, Senator, I could not tell you how many valuers out there. We have a panel, as I think we've explained to you previously. But as to how many valuers in total there are, I don't know. We do know that some valuers are members of the Institute of Chartered Surveyors, the organisation you heard from today, and some valuers are not.
And how much does their membership of a particular organisation influence your determination of whether they should be on your panel or not?
We select our valuers based on a range of factors. One is expertise, experience, knowledge of the particular asset class, so it might be whether it's a shopping centre or commercial or hotel, for example. Their size of organisation, the extent of resources.
So how do you know the size of organisations and we can't find that out?
Size of organisations, we know very well the size of the organisations that we deal with regularly. So it's like, for example, dealing with a large law firm or an accounting firm. You know the firm, you know their capabilities.
So would you be able to, Mr. De Luca, you want to answer that?
I was also going to say location as well, because we want diversification across the country, because of, obviously we've got spread of customers all across the country.
It would be helpful for the committee if you could give us a bit of a mud map of the lie of the land as you see it, and if you have any understanding of the different levels of probity and oversight that are embedded in the different organisations that give the valuation certification, because it seems to me that there seems to be quite a bit of variation within different organisations, and certainly the quality of the evidence we've received has been very variant.
Yes. How many are on the panel?
How many valuers are on our panel? Individual firms, I don't know off the top of my head, Ms. Ruddock, but we're talking, we would have at least a dozen valuers, and in fact, when you take into account all the geographies, there'd be many more than that.
If there's not hundreds, no, which is interesting what we have. If a valuation is in dispute between the bank and the client, what processes do you have in place currently to deal with that, and what processes going forward, given the fact that you're not sharing these with people yet, generally, do you propose?
So, Senator, at the moment, there is no formal process that is in place, so that if we obtain a valuation and if the customer believes that valuation is flawed for some reason, there is no formal process in place. Having said that, we are, particularly if the case or the client account is being handled by our area that deals with distressed or impaired loans, then there is regular communication between the two, so there would be an opportunity at least for a discussion. But to the point that we made earlier, because the client does not automatically receive the valuation, there isn't an automatic way for the client to say, I object to that valuation. Firstly. Secondly, in terms of going forward, in line with the comments we made in December about the appropriateness of providing valuations, that at least would bring the issue out into the open fully. That, I suppose, could lead to an opportunity. I haven't given any thought, Senator, to whether there ought to be a formal mechanism around the client being able to dispute the valuation. But clearly, if the customer is given a copy of the valuation, there would be a much more open and knowledgeable discussion on both sides around that valuation.
How would it impact on the efficiency and business of the bank if at the commencement of business, the terms and conditions that were set out for the valuation were provided to the client? Then at a later point, they would have that as a point of reference to refer to. Would that be a major imposition on the bank to provide that at the point of the commencement of the banking relationship?
No, I don't believe so. In fact, the practice, and Rob can comment on this in a bit more detail in a second, but the practice generally is that when a valuation is obtained up front at the time a loan is applied for, there is a discussion with the customer about the valuation, because that valuation sets the security level, if you like. In other words, to what extent is the bank secured by that particular property.
So seeing as it's already undertaken, it wouldn't be a major problem for you to hand that information on to the person to hold?
No, I don't believe it would.
No. At the point of the origination, the client would have input into the instructions. And to your question earlier, there are times at the point of origination that the customer that may disagree with the valuation, if there is another valuer on the panel that they're happy to pay for, we do give them the option to get another valuation.
So they can pay twice to be unhappy?
Yes.
So, moving further down the line there, now you've indicated a willingness to consider sharing these valuations. I'm assuming at each of the points that we're discussing, whether it's at the happy beginning or the distressing close, that you're proposing to share that. When do you think that will be the case, Mr. Cohen?
Well, that's a good question, Senator. I haven't actually raised it within the business as something we're doing yet. It is something that we're comfortable with. We wouldn't have suggested in December otherwise. I guess one of the issues that has been on our mind is what recommendations might come out of this inquiry. So we will be interested, very interested, to see what it is. But as I said, we think it's a good idea. We'd be happy to do it.
So I have to say, given the public relations drama that's surrounding banking at the moment and your bank, I'm surprised that you haven't taken the opportunity to do something of that kind already. And maybe we can wait for it next week or the week after. We'll see. Could I go to Basel 1, 2, and also in today's Sydney Morning Herald, last question. So in today's Sydney Morning Herald, there was an article by Ms Rose and Mr Ayres, I think it was, around the concern about, I think it was characterised by ANZ as Basel 4, about the nature of the brittle economy, APRA suggesting there's still work to do to reduce reliance on short-term funding, and that there will be a high capital requirement. One of the concerns that's been raised with this committee was that the Basel 1, Basel 2 change meant that there was a different requirement on the bank and that there was some incentive there to change your loans structure to comply with Basel. And my question is, it's been put to the committee that under the Basel II rules, APRA required Bankwest to significantly increase regulatory capital held for non-investment grade corporate loans on the Bankwest book. Do you have a view to put on that, Mr. Cohen?
Yes, I can. If I can find the particular letter that we've sent you, we've already commented on that, and we've said actually there was no incentive through the Basel capital impositions to change the treatment of loans.
And I keep hearing Basel and Basel, but anyway, I know that both of them are in active use, so that's okay. In terms of the capital that's required to be held, and increasing capital demands on the bank going forward, should people with commercial loans be concerned that the bank might be beginning to reassess them if capital requirements demand that the bank changes the capital that it holds and reassesses its risk with regard to commercial loans and lending?
What I will say is that probably the group of stakeholders who are most concerned at the moment about increased capital holdings are investors, because the more capital that is held and that can't be utilised in the business, the lower the return on equity for the institution as a whole, and therefore the lower the return that a shareholder receives. It's a fact that all of the Australian major banks have significant foreign investors, and those foreign investors make their decisions on where to invest based on the return that they can get in the various investments they make. So we do hear that there is a degree of interest, perhaps even heightened interest, amongst foreign investors around how the capital implications for Australian banks will pan out in terms of the return that they receive on their investment in the bank. In terms of customers, which I think is specifically what you're asking about, we don't anticipate that holding more capital, whether it be for prudence or whether it be for operational risk reasons, we don't believe that that is going to impact adversely on the organisation's willingness to make commercial loans.
Because one of the arguments was there's a critical transition period around the time, the 1st of January 2009 from Basel 1 to Basel 2 that impacted at the same time because of the purchase of Bankwest on the capital holding of the Commonwealth Bank. those two things are not connected in any way in your view?
No, sir.
Okay.
Mr. Ruddock.
I noticed on the 15th of February Mr. Narev, you may know him, was interviewed by Dickie Fullerton. They were speaking about a Project Magellan, revaluing of thousands of commercial clients' loans by some 75%. And I think Mr. Narev went on to say that it was important to understand the history of the purchase of the bank. It was really struggling for a number of reasons. It didn't have a strong funding base. It had done a lot of lending which was not prudent, and lending that the Commonwealth Bank certainly wouldn't have done and didn't do in those circumstances. And he went on and said he wouldn't characterise it as over-aggressive lending, but I mean most of the difficulties we've been working through over a period of time has been a result of loans that were on the book when we bought the bank, and we've over time made sure that the lending standards and pricing have become prudent as a result of what we've had to work through some difficult situations with clients. So perhaps it's not surprising that people may be looking for motivation when, as he didn't rebut, it was suggested that there were thousands of impaired loans. So I was interested today that you characterised it, as you said there were no inappropriate motives, as being less significant, perhaps only 46 contested loans. And I wonder, if it's such a small problem, why you're not in the same club as the ANZ, endeavouring to work these issues through in a way which may resolve some of the contested questions. Now, let me just say that I would love to be able to forensically go through each of the letters that you have adduced for us, and for which I thank you. But the parties haven't seen them. I don't know whether or not they agree with the assertions you've made or contest them. I suspect numbers of them do contest what you have put. So I ask myself, and I put this question again to you because I've done it before, whether the bank, rather than waiting for some recommendations from us, is prepared to be proactive in putting in place a genuinely independent commercial arbitration or mediation where people are properly resourced, particularly those that have been wound up or bankrupted, to be able to test these issues and to have them resolved in a way that brings this matter to an end.
Order. Could I have silence, please, in the public gallery?
There, if the bank is minded to take it up.
Thank you, Mr. Ruddock, for the question. Firstly, all the responses that we have given to the committee are available on the website, so all customers have access to them. And I'm not too sure if all customers have read them, but all those facts are there, number one. And we've been very deliberate in being as open as possible, and as being as fulsome as possible as well, for that very reason, that we expected these responses to be publicly available so that not only committee members but customers and the public can form a view, number one. Secondly, we have provided to the inquiry very detailed responses to the allegations made, and the committee asked us to look into 8 cases in particular, which we've done, and very happy to do so, and very happy to provide the fulsome answers that we have. In each of those 8 cases, we have answered the various allegations that have been made by customers when giving testimony to this committee, and we have sought to show exactly where those allegations are not correct. Now, I do genuinely understand the emotional distress and the financial distress that goes into, or that occurs when a business does not succeed as hoped. And I do recognise that there's significant emotion involved. However, what I will say is that we have sought to deal with allegations that quite often are general and quite often are not specific. In some cases they are specific, but in each case we have sought to deliver a very specific, fact-based answer so that at least everybody can be as fully aware as possible on the actual facts. And I would say that so far, on all of the facts and the information that we have given the committee, notwithstanding the fact that the wind-up of a business or the sale of an asset or a business not succeeding as hoped is emotionally distressing and financially distressing, then the fact of the matter is that does not per se make the actions of Bankwest or Commonwealth Bank wrongful. And we have sought to show you, through the information that we've provided, that there has been no wrongdoing on the part of Commonwealth Bank or Bankwest.
I take it the answer is no. But let me just say, our terms of reference don't permit us to bring counsel in and to have, I mean, the chairman will bring me into order fairly soon when my questioning gets going and say there's no more time for you. We've got to share it with some of your colleagues. I mean, this is not the forum in which that can be done. But we do have, on my email system today, two people who must have known you were putting this information on the website and have sought to rebut comprehensively many of the points you have made. Now, I don't know how I'm going to be able to resolve those issues. And I just put it again, rather than us having to recommend that there be a Royal Commission to deal with these issues comprehensively, because there are matters unresolved, are you prepared to look at some form of independent and genuinely independent mediation?
So, Mr. Ruddock, I don't believe there is a single thing that a committee member would want to know that you can't obtain from us simply by asking the question. And you have asked many questions.
Order. Ladies and gentlemen, this is a public hearing. I would ask you to listen in silence. If you can't show the witnesses that respect, I will ask you to leave. Mr. Cohen.
Thank you, Chairman. So, this committee has asked us over 50 questions on notice. We have sorry, Mr. Ruddock, I'm going to answer your question. We have provided factual answers, we have provided information, and we have been completely open. We've shown a complete willingness to answer every single question that the committee has asked and to provide everything that the committee has sought. There is not one thing, I think, that a committee member could want from us that you could not obtain simply by asking. It's going to be up to the government to decide whether a Royal Commission is necessary, but based on what we have provided to you and our willingness to answer every single question you've asked, a Royal Commission does not seem warranted.
Well, I just make the point. I mean, I know how you can do it in a proper tribunal where you've got unlimited time to forensically test evidence before you, and these committee processes do not lend themselves to that modus operandi. I mean, it's just very clear. You're here for 2 hours. The chair will share the time around amongst the members. There is not an opportunity for that sort of forensic analysis, and our terms of reference don't permit us to examine individual cases on that basis. So we have to find a way forward to deal with the matters that I believe, on the evidence that's been put to us by you and those who have responded to the evidence that you have put to us, needs to be resolved.
Are you complete?
Yes.
Senator Kettle.
Yes, thank you. Mr. Cohen, if I could just return to the issue of perhaps the scale of the problem and the quantum of the loans that have been defaulted here in comparison to the population size that we're dealing with. And I'd like to sort of try to come to grips with the population size. And you've indicated in your opening comments that there were 26,000 customers of Bankwest, and I'm interested in just digging into that number of 26,000, it's possible that number includes, it's your broader commercial customer base, which includes business deposit accounts, business cheque accounts, business credit cards, and therefore might be comparing apples with oranges to some extent. So what I'm asking is, can you give us, is there a distinction between commercial customers and SME commercial loan customers?
Senator Kedder, if I can, the numbers that we've provided there are commercial lending customers. We have about 87,000 commercial and business customers overall at the moment.
Right.
So these relate to customers who have actually had borrowings at the time, either at the acquisition or today.
So 87,000...
Small and medium-sized commercial businesses. So the remaining customers would be a number of customers that may have just a business credit card or a deposit with us or just a merchant facility.
So they were Bankwest SME...
No, 87,000 customers today, total.
No, boss, sorry,
Yeah.
I want to go back to the 19th of December 2008.
Yeah, so the over and above the 26, I don't have the number of at hand, but it'd be more than the 26,000 that you've got in front of you, which were customers that didn't have borrowings but would be SME customers.
Okay. And in terms of the value of the loan book, I think Mr. Cohen has given evidence that it was $23 billion as at the date of acquisition, 19th of December 2008. Is that your evidence?
Yes, so broadly speaking, the commercial loan book was, yes, 22.8 billion.
Right. And so I noted that Bankwest reported in their capital adequacy and risk disclosures quarterly update in the 31st of March 2009 that commercial loans were to the value of $14 billion, which is a significantly lower amount. Would that figure be correct?
That was at 30 June 2009, did you say, Senator?
31st of March 2009.
Oh, sorry. 31st of March 2009.
So is that a exposure number
Yes.
or facilities number? Do you know?
I just note that it's in this capital adequacy and risk disclosures quarterly update, so I'm not quite sure what the actual...
Yes, that is not necessarily the number, or it's not necessarily the full exposures that we faced to customers as a result of loans. That could be actually the exposures at a capital level that we were holding.
So it's not comparing apples with oranges?
No, I don't think it is, Senator. I'd have to have a look at it in detail for you, and I'm happy to. But just off the top of my head, it doesn't sound like it's a direct comparison.
So what is the explanation for the disparity between the 23 billion and the 14 billion?
It sounds to me as if that number that you're referring to there, the 14 billion, is more likely either a number based on the capital that we hold against the loans, which I suspect it is, which is not necessarily the same amount as the full exposure under the loans.
All right. Okay. Now, I just wanted to go next to the commercial loan warranties. And I note that Freehills, on behalf of CBA, sent a letter to HBOS reserving CBA's rights in relation to a number of warranties. That's correct, isn't it?
Yes.
And I see you nodding. So
Yes, 3 warranties in particular.
right. And these were separate to the 67 commercial loans that were subject to the draft completion balance sheet dispute notice.
That's correct.
Yep. And you've given evidence that CBA's made no formal warranty claims in respect of customer loans.
Yes.
Did you ever proceed with the warranty claims that were flagged in that Freehills letter?
Yes, so those 3, we wrote to HBOS and said we believe that HBOS was in breach of 3 warranties. One warranty was in relation to basis swaps, the other was in relation to invoices paid by Bankwest for IT platforms, and the third was a claim relating to the discovery that certain letters of credit and bank guarantees provided by Bankwest to or on behalf of the HBOS group were off balance sheet. So those were the three issues that we raised with HBOS. We claimed that those were breaches of warranty. In the end, rather than actually proceeding all the way through with a dispute with HBOS, we agreed to settle the claims for $5.3 million.
So they were formal warranty claims but were settled?
No, they weren't formal warranty claims because we didn't go through the warranty process set out in the sale agreement. Instead, what we did is we wrote to them saying, we think that you are likely to be in breach of these warranties, and we in fact commenced some legal proceedings at a very, very early stage around those because they said, no, we don't think we are, and we settled those legal proceedings on the basis of a payment of $5.3 million to CBA.
So there were no warranty claims in respect of commercial loans?
That's correct. That's correct.
Right. And perhaps not formal warranty claim, but were there any sort of alternative settlements reached in respect of commercial loans that may not have gone through the
No.
warranty process?
No, none whatsoever. So, as you recall, I think, Senator, the only process around commercial loans was around impaired loans, and that was through the price adjustment process that we undertook in 2009.
And the settlement which Dr. John Schubert referred to at the 2009 AGM as a confidential post-acquisition settlement, can you tell us what that one related to?
Off the top of my head, I don't recall what he was referring to. The only post-acquisition settlements that occurred would have been the one around the three warranties that I've just described to you that did not relate to commercial loans. And that is about all I can recall. I'm not too sure if you have anything there that is a bit more specific.
No, that's all I've got.
No,
Yeah.
no, I can't. We can look into it for you, but I think that would be what he'd be referring to because that occurred. That settlement occurred in December 2009. So did you say he was speaking at the 2009 AGM?
AGM, yeah.
Oh, well, the December 2009 would have been after the AGM, I think. So we'll have to look into that for you. But
Okay. Is it possible that that post-acquisition settlement didn't relate to warranties? It could have been some other settlement.
I'm trying to recall whether there was any other form of settlement. We had a number of IT contracts in place with HBOS, whereby Bankwest was continuing to use HBOS IT platforms, and that we finished those a little bit early because we managed to transfer Bankwest over a little earlier than planned, so it may have been in relation to that. But there was no significant post-acquisition settlement. The major thing that happened was the July 2009 finalisation of the purchase price, which involved CBA paying back the remaining wholesale funding that Bankwest had borrowed from HBOS, number one, and secondly, the price adjustment process through the independent expert.
Right, but you'll come back to us with...
Yes, I'll
that.
certainly look into what Dr. Schubert was referring to at the AGM.
And will you be able to give us a quantum of that
Oh,
settlement?
yes, I'm sure.
Yep.
Yes.
And I just wanted to return to the vexed issue of Basel 1 and 2 and to try to understand that a bit more. And I think this has obviously been touched on many occasions, but it's been put to us that APRA required Bankwest to significantly increase regulatory capital held for non-investment grade corporate loans on the Bankwest book. And that would have been under the Basel II requirements. Would you know anything about that?
When was that, Senator?
I don't have a specific date for that. But
So there was a process for Bankwest which it went through Basel accreditation. It had its accreditation revoked, I think, in 2013, not following certain processes that it needs to rectify. So currently going through a process of reapplying for accreditation. So if it relates to that, it means that the portfolio needs to be assessed on a capital basis, on a standardised basis, versus using our own models.
Right.
That'd be I think the difference.
okay, well, My information is that Bankwest changed from Basel 1 to Basel 2 on the 1st of January 2009.
Yeah, that was early, that's correct.
And that's 11 days after the acquisition.
Correct.
Okay. So did those Basel 2 regulations require Bankwest to hold significantly more capital for non-investment grade loans?
Not to any material respect as far as I can recall. There was no significance. As you probably know, Basel 1 and Basel 2 represent a difference in evolution of the capital standards, and also looked at allowing banks which had more advanced risk management systems to internally rate and internally model their risk profiles. That was one of the significant differences between Basel 1 and Basel 2. CBA and the other large banks, you're probably aware, were able to effectively use their internal modelling systems in order to risk rate. Under Basel 1 that was not possible, under Basel 2 that did become possible. That did not happen immediately for Bankwest, and therefore didn't make any significant difference to Bankwest.
I note that the timing of the change from Basel 1 to Basel 2, as you pronounce it, was very close to the date of acquisition. Is there a particular reason for that, or is that a coincidence?
Oh, that's purely a coincidence. The introduction of Basel 2 was well flagged in advance, so that was known by the industry for many, many months before the commencement date. In fact, the banks had been doing a lot of work in the lead up to the introduction of Basel 2 in order to show that their internal risk modelling systems were sufficient to get what's called the advanced accreditation status from APRA.
So you're telling me that there was not much significant additional capital that needed to be raised by Bankwest to meet those requirements?
No. So, no, there wasn't any significant difference. To the extent that there was any difference, it was effectively provided through Commonwealth Bank now being the parent of Bankwest.
So there's some sort of internal realignment or a new methodology of calculation, is that what you're saying?
No. What I am saying is that one of the advantages for Bankwest of having Commonwealth Bank as its parent was that Commonwealth Bank was very well capitalised at the time, whereas HBOS had found itself in a very challenged capital position at the time. So one of the advantages for Bankwest was it was able to rely on CBA as a well-resourced parent, and secondly, and very specifically, Bankwest was able to rely on Commonwealth Bank being able to raise wholesale funding in wholesale funding markets at rates that were more advantageous to Bankwest than if it had been trying to do so on its own, which at that point was very difficult.
Okay, look, and I wanted to move to your review of Bankwest's loan book.
Yes.
And just wanted you to confirm that the assessment of the loan impairment provisions and the proposed adjustments carried out were in accordance with Bankwest's accounting and credit policies as at the 31st of December 2007.
Well, the review was carried out in 2010, so this is Project Magellan I think you're referring to. Is that correct? It's
been referred to in that way. I'm talking about the assessment of the loan impairment provisions.
Yes. So that was an exercise that was called Project Magellan. It was carried out in May and June 2010 and involved a review of about 1,200 files, which was approximately just short of 50% of the commercial loan book. So your question, I think, Senator, was...
well, so which
was that in accordance with accounting standards that applied back in 2007?
Yes.
They would have applied then current accounting standards.
From 2010?
Yeah, what was prevailing in May and June 2010.
Right.
Because those accounting standards would determine the rules around impairment, and obviously you would have to impair according to the then existing accounting standards.
Well, is it correct that the commercial loans were reviewed for accounting purposes and reported to relevant regulatory and audit bodies on a downside or conservative or worst case basis?
I'm not familiar with reporting to, pardon me, to accounting bodies. The way impairment is carried out is that a view is taken on whether or not the loan is going to be fully or partially recoverable and whether any losses might be incurred on that loan. And the requirement is that once an impairment becomes evident, then the organisation is required to make an impairment provision. So that would have occurred, that was part of Project Magellan, and having made an impairment provision, then an equivalent impairment expense is taken to the income statement of the bank.
Well, I'm aware of an email between Mr. Michael Hayes, National Manager Portfolio Group's Bankwest, to Catherine Porteous, I'm not sure of her position within the
CBA.
That's
right.
On the 27th of March 2009, where Mr. Hayes says, and I quote, "Catherine, as per our telephone conference call on Wednesday, I've been asked to remind all that the papers have been prepared as instructed on the basis of downside risk, in most cases representative of insolvency, enforcement of our security, and these strategies are not representative of anticipated likely case outcomes currently being pursued."
Yes, I think that's an email, if I recall, Senator. That's an email talking about the basis on which impairment calculations were carried out. And so as staff went through each file, thinking of the impairment that the bank might have to raise against that loan. So that's quite different from a default and quite different from a loss or a write-off. It's just a view on how much might be lost on that loan in the future. Now, impairment is a dynamic process. It occurs regularly, and so impairments can go up if the situation is looking worse, but if the situation with the particular borrower and collectively across a portfolio improves, then impairments can go down as well. I think that is an email from memory that refers to the basis on which the impairments would be calculated for the purposes of raising an impairment provision.
Right. So did you instruct, or did CBA instruct Bankwest credit officers to conduct such a review and report the results back to CBA, even though they were not representative of anticipated likely case outcomes being pursued?
The Project Magellan exercise was carried out and the results of that exercise were reported back to CBA. CBA asked for that project to be carried out because we had seen over a reasonably regular basis in the period between acquiring Bankwest in December 2008 and May 2010, we had seen on a number of occasions we had seen Bankwest raise impairment provisions in lumps, and it was felt that what we had to do was actually to look through the book to get a proper view of what the impairment situation was, rather than getting surprised every now and then by a sudden lump of impairment.
Okay. So, I mean, the question for me is, were those impairments assessed on a downside, conservative or worst case basis?
Not worst case basis, no. They were certainly assessed on the basis that in the past a number of impairments had not come to light sufficiently quickly, and that had been our experience. I think it is fair to say that impairments had not been recognised as promptly or as regularly in the early stages of CBA's ownership of Bankwest as CBA was used to, and certainly not as regularly or promptly as CBA itself practiced.
And were the results of that review used to characterise non-impaired performing loans as at the 19th of December 2008 as having impairments prior to that date?
Sorry, sir, I don't think I understand the question.
Yeah. Were the results of this CBA instructed review used to characterise non-impaired performing loans as at the 19th of December 2008 as having impairments prior to that date?
Oh, I see. No, the impairments were calculated as at the date the impairment review was carried out, namely May and June 2010. So it was a view of the impairment situation of a loan as at May or June 2010. Not what it would, not retrospective, exactly.
Okay. Look, just one further question. Were HBOS informed during any dispute process that this basis of Bankwest performing commercial loans were undertaken by the CBA?
In 2010, at the time that review of impairments was carried out, we were not then dealing with HBOS. The sale had completed. HBOS had been taken over by Lloyds, which in turn had been bailed out by the British government. There was no dispute process ongoing. Once, effectively, Senator, from July 2009, so about a year before this impairment process was carried out, we ceased our dealings with HBOS because there was nothing further to deal with them on, so there was no dispute.
Okay. Thank you, Chair.
Thank you, Chair. Thank you for your testimony today, and probably to disclose up front, I used to work for the Commonwealth Bank many years ago. I'm interested in this whole process, particularly around the Bankwest book. What work has been done with the Commonwealth, or by the Commonwealth Bank since its acquisition of Bankwest, to identify and ultimately report, or self-report, any breaches of the Banking Code of Practice?
We have a process in place across the group, so it's not just specific to Bankwest. And that process across the group is to comply with our reporting obligations to the Code Compliance Monitoring Committee. So Bankwest is very much part of that, just as the other areas of CBA are.
So have you identified cases where there have been breaches that hadn't previously been reported and subsequently reported those breaches?
No, we have not identified any such cases.
Okay. Because I find it interesting that from 2007-8, so around the time of the GFC, reporting of non-compliance with the Banking Code of Practice was running at about 1,000 per year. And as of 2013-14, it's now running between $5,000 and $6,000 a year, and it's got up as high as over $7,000 a year in terms of reporting of non-compliant breaches for the Banking Code of Practice. So I find it strange, given the broad-ranging discussion we've had, both in relation to Bankwest but also others, that there's no self-reporting of breaches, and I find it hard to believe there haven't been any breaches that have occurred in that process.
I'm sorry, Mr. Van, when you say there have been no breaches occurred, we have been reporting breaches as in the normal course of events, so I answer your question.
That's what I asked, is have there been breaches reported?
Yeah, sorry, I understood your earlier question to be, have there been breaches in relation to specific Bankwest cases that we have subsequently identified and reported, and the answer to that was no.
Okay.
However, generally speaking, yes, we do report breaches to the Code Compliance Monitoring Committee for breaches of that code, yes. Yeah. Yes, we do.
Okay. And
that's across the group.
Okay. I want to go to an area that we probably haven't really touched on, just without referring to any specific clients, but to pick out one particular case that you've outlined to us in a response to a question on notice, for a customer that was in difficulties and had a very substantial loan facility. I'm just concerned at some of the fees that are levied on people who are already in difficult situations, and then you levy substantial additional fees on top of them, which in my view just makes the situation worse. In this particular customer situation, the increase in the interest rate on their facility resulted in an increase of some nearly $2.4 million just in their annual interest liability, in addition to which you charge a $75,000 fee for the privilege of increasing their interest rate. you charge an additional fee subsequently for an extension fee of $100,000. You subsequently charged about 4 or 5 months later about 6 months later or so, where you change the facility around, but you charge a $600,000 fee, and subsequently charge another $25,000 fee. So in the space of 18 months, you charge $900,000 in fees approximately, plus an additional interest bill of $2.4 million. How, in a situation where a business and a client is already in trouble, can you possibly justify, in the space of 18 months, charging additional costs to a business that's already in difficulties of some $3.3 million?
So I'm happy to explain that. The customer you're talking about is an ASX listed company, CEC Group Limited, as you're aware. Each of those fees that you're talking about is actually it's not a fee for being in trouble, it's not a fee for doing anything wrong, it is a fee for extending the facility in each of the cases you've mentioned. And as we pointed out in our letter to you of the 31st of March, the fees were charged for extending facilities that had expired. Now that is absolutely standard practice. When a borrower takes out a facility, they get charged what's called a facility fee. In this case, when the facility had expired and the bank decided to support the customer by extending the facility, notwithstanding the fact that it hadn't been repaid, a facility fee was charged because it was in effect a new facility.
Mr. Cohen, can I ask a question of clarification there?
Yes.
The facility provides the framework within which you lend capital and the consumer pays capital and interest back, or
yes,
capitalises interest, whichever the structure is. What's the value offered by the Commonwealth for the 3-point-something million fee, if, as you've stated, your intention is to work with the company to help them work out of their problems?
Yes.
What is the value added by that fee as opposed to the long-term business proposition of them having a loan?
So the value is the continuation of the funding. So in effect, Senator, the fee is charged for not requiring the facility expires. The customer in this particular case, CEC, came to the bank on each occasion to say, we're not in a position to repay, we'd like to continue the funding. The bank at that stage had the option of either continuing the funding and working with the customer to achieve some pay down milestones, which CEC sought to achieve. In return for that, the bank agreed to continue the funding and agreed to, and charged a facility fee for continuing the funding. The alternative was to say to the company, well, we're not going to extend the facility, so the company would have to find either another way of repaying the bank, which would either be through refinancing or sale of assets. In this particular case, CEC did undergo a program of selling assets as well to reduce its debt.
So, in effect, what you're saying is when you argue that you're prepared to work with the customer, you will work with the customer on the basis that you make a very handsome profit along the way, in this case over $3.5 million, of a fee that actually adds nothing to the customer's survivability except for the fact that the facility continues.
Well, actually, that's a major factor in the survivability.
But, Mr. Cohen, your argument to us to date has been that the bank bends over backwards to help the business survive because it's in the bank's long-term interests and the customer's long-term interest for them to be able to continue under the loan agreement that they will pay out that loan. What we've seen in many cases is that companies that may have had a 25-year facility, when they reach a point where there is a cash flow crisis or perhaps there is a change in valuation and processes put in place by the bank, fees like this to a lay observer such as myself don't appear to be adding much value to the company in terms of meeting that long-term proposition of working through the loan for that 25-year period, in the case of one of the submissions, that was the original agreement the bank had with the customer?
Well, in this particular case, Senator, the facilities had expired, and so the customer was in a position where it owed $169 million. The facility had expired, and the customer was faced with a situation of how to move forward. It had a discussion with the bank. The bank agreed to continue the funding, to continue to lend $169 million. Now, the bank's situation here is it has a certain amount of capital set aside for that particular customer. It had worked on the basis previously that that capital would be returned at the expiry of the loan, and that the bank would then go and use that capital to lend to another customer, hopefully. In lending to that future customer, it would have charged a facility fee. In this particular case, the customer asked that the facility be extended, so the bank forewent the opportunity of taking that capital and lending it to somebody else, and instead stayed with this customer, kept the funding going, which I agree with you, certainly had a benefit of the customer being able to continue in business, and therefore that is a benefit to the bank as well, absolutely. But it is in effect a fee charged because the bank was no longer able to use that capital as it was going to do when the facility was due to expire.
Can I ask a question on that?
Yeah, and then we'll go back to Mr. Van.
So, how much does it cost to get 169 million? Is 900,000 the average cost, or is that excessive or small, or was that a special deal for a favoured customer?
So do you mean the interest charged or
was there
the
a
fee
900,000 facility fee? Am I understanding what's been said correctly?
No, the fee charge was $75,000 for $169 million.
Okay, so in terms of that business, it would seem that they were sort of a bit over a bit of a barrel, and then you come in and give them a bit of a whack on the way through. So what sort of capacity really does a business have at that point, where it's in a crisis, to go to another major bank and say, we would like to establish another facility?
Well, Senator, what I would say is that in those circumstances, if the borrower did go to another bank to refinance, for example, so if they'd gone to another bank to refinance that $169 million, naturally that bank would have charged a facility fee, just like any bank would. And so the customer would have paid that fee. That in
How much is that likely to be, Mr. Cohen?
Sorry?
What is the facility fee for that sort of amount? Is there a sliding scale? Is there a common...
No, it's a commercial matter between the parties. In this case, it was 0.045% of the facility amount. Now, that is not an unusual amount at all. It does depend on institution by institution, and it is a commercial negotiation between the parties, but that amount of fee as a facility fee is not an unusual amount, and I think you would find it would be in that range or thereabouts for most
Does
banks.
it go up as the
Well,
company looks like they're getting into more trouble, or does it go down?
No, it doesn't at all.
Which
it doesn't
one?
All. It does not go up just because a company is facing difficulty. For the very reason I think that Senator Fawcett was alluding to, namely, if a company is in difficulty, charging it more is not going to help it unless it has a sustainable plan to get through.
But in that commercial decision-making moment, you could actually reduce the amount to keep the facility going.
Oh, yes, that is absolutely possible, and the assessment is made at the time on the basis of the customer's financial circumstances.
Okay.
Mr. Van Manen.
Thank you, Chair. I'd like to move back to seems to be a favourite topic today of valuations. Is there the capacity in the valuation methodology to say you got a new client in 2010 and their facility, their assets were valued, and then in 2016 they get themselves into some difficulties. So you're revaluing their assets and their business to see where you're at. To actually publish those two or report those two valuations side by side so customers can clearly see the assumptions that were used in the initial valuation report and the assumptions that we used in the new valuation report to be able to clearly explain to the customer and for them to see what has changed, and for there to be a discussion around that, because that seems to be a significant part of the issue from what I've seen and heard, is that there's little understanding or correlation in that valuation methodology from when you do the initial valuation to subsequently you do a valuation when a business or a client is facing difficulties.
Yes, and I would say that the greater the transparency, the better the opportunity of avoiding misunderstanding. I agree with you entirely. And I think a little towards our conversation earlier today, that's a matter that we think is a benefit going forward. Of course, where there is the longer the time period between the initial valuation and a subsequent valuation, the more that there will be difference in terms of value potentially, but that's just a market force issue. The actual going in assumptions, though, which I think is you're referring to, I think there is a benefit in greater transparency around those.
But would it be fair to say in any of these cases that we look here that you've provided a response to us in terms of questions on notice, whether it's CEC or any of the others, they have very significant loan facilities in the majority where they would have had business relationship managers that
Yes.
would have been responsible for those clients and their relationship. Wouldn't there, in the ordinary course of events, and certainly in my time in the bank, when you met with customers, you discussed what was going on in their business, you discussed economic conditions, issues they are facing, etc., etc. I would have thought that in these situations, given the size of these loan facilities, that would have been a very regular discussion between the responsible relationship manager and the client to try and forestall some of these issues far before it became a problem.
Mm-hmm.
Yeah, certainly in my experience, during these times, the conversation increases in terms of the frequency of it. Obviously, during post-GFC, the market was moving quite significantly, so some of the views of what was actually going to happen were unknown.
But if you had a set of valuation metrics that you used to write the business in the first place, is there ever in those review discussions as the relationship proceeds a reference back to those valuation metrics to say to the client, look, we're 18 months down the track, we've had a global financial crisis, there's a number of issues as a result of that. This is the basis on which we first lent you the money. What has now changed in relation to those metrics? Or what issues do we see? What, if any, of those discussions were had? And if they were had, what was the outcome of those discussions? And how did that affect what subsequently happened down the track?
I think in some of the responses we've provided, I think we've outlined the ongoing conversations with a number of customers during that period. Obviously, they'd happen case-by-case basis. And I think in terms of the facilities, as we've outlined, have changed during those periods as well, based on the impacts of valuations, but also the impacts of the financial performance of the business. So they would be the discussions, and as David alluded to earlier, generally across a number of these were long-term discussions from the start of the crisis till subsequent events.
In relation to the book of business with Bankwest, and one of the major topics of discussion out of the GFC was the issue of securitisation. Was there any portion of the book of business with Bankwest that was securitised?
No, there was no commercial facilities in securitisation at the time of the acquisition.
Okay. And I asked this question of ANZ earlier, but for commercial loan facilities, what are the capital adequacy requirements? Is it 100%, 50% of the loan facility?
Depends, I think, as David alluded to earlier, of the approach taken. So when we moved to Basel II, it was a standardised approach, which was consistent across all of the facilities. Under current regime, it's... I can't remember off the top of my head. It's been a while since.
Yes, off the top of my head, Senator, I can't recall.
We can come back to you on that one. I don't recall.
Well, you now that you're under the Commonwealth Bank banner, you're under the advanced.
Yeah, the advanced accreditation
process. So under that process, what's the capital adequacy requirements on a commercial loan of $100 million?
It's done on an individual basis because it's basically the advanced approach is you use your own models, and then depending on the risk ratings of the loans, the term of the loan, the industry type, it's done on an individual basis. So each one is different.
So, and the theory behind that is that those organisations that have invested heavily in their risk assessment processes and their risk modelling are better placed to be able to determine how much capital should be held against each individual loan according to the circumstances of that borrower, the industry that it sits in, the prospects for that industry and the prospects for that business.
So you would then have your own internal metrics of if you increase the risk profile of a particular customer's loan facility, you have an internal metric then as to whether you are required to hold more capital for that loan or not. Well, that can be a value judgment, or is that a very black and white requirement within your risk management and capital adequacy or capital management processes?
If the circumstances change for the customer, if the risk rating changes, if the size of the facility changes, if the term of it changes, if the purpose of why they're borrowing changes, so if it started off as just commercial property and then expanded into a business, all those factors are taken into consideration and thrown into the model, which then provides you a view of what the provision should be.
And is that the basis on which you then apply whatever margin is applicable over and above your base interest rate margin?
That's an input into the pricing.
One of the factors,
Yeah.
that's correct. Yes.
Thanks, Chair.
I mentioned to you earlier that we've had a number of letters putting other views to us on some of the matters that we have under discussion. There was one letter I noted today I received from a Mr. Sean Butler, who apparently wrote to you on the 25th of February, flagging a number of questions. Have you brought with you an answer to that letter?
No, I haven't. That's right.
He does raise issues in relation to requests for meetings. He said that Mr. Luca, for instance, had sent him a letter on the 11th of March stating, "We met with you in the presence of an independent person in an attempt to resolve your concerns." Mr. Butler says that that is untrue. And there are a series of other questions that have been addressed to us, which go to questions of substantial differences of view in relation to allegations made. I'm just going to see, did the letter of the 25th of February suggest that he was... He said he sent the letter to you by registered mail. I'm just surprised that you haven't come prepared to answer the questions.
I've got a copy of the letter in my response on the 11th of March, Mr. Ruddock, so have responded to Mr. Butler, and we're happy to provide the committee with all the documents that support it in terms of the meeting that was held
So you believe that in relation to the matters he has raised, you have further responded to?
Yes.
No, he hasn't. He hasn't. Order.
We can give the committee our letter of the 11th of March.
Yeah.
That might help.
So just clarify, what form of response has been sent to Mr Butler?
A letter to his email address.
Okay. And is it possible for you to provide a copy of that for us now?
Yes.
Definitely.
Thank you.
We can have it now.
Senator O'Neill.
If I can return once again to matters of culture, I understand that banks have become increasingly aware of the need to do things in this area. Could you explain to the committee the sort of work that you're undertaking? I'm providing you with an opportunity here to put on the record that you are proactively doing some things, but I do want to also express, just in the exploration of that one issue with regard to access to valuations, that there still seems to me to be some considerable gap between the language and the talk around cultural practice change and the practical realisation of that in a way that would give me more confidence about what the bank is doing, particularly in light of other matters that are in the media at the moment.
I understand.
So could you speak to the cultural practices that you are attempting to undertake and give any indication of the practical application of those in terms of addressing some of the concerns I think that you're very aware now are exercising the minds of this committee? That's the first part of my question. The second part is, you appear to be awaiting our report. Our report is hopefully informed by evidence that we receive from all participants, both civic participants and commercial participants in your case. I'm also keen to hear from you recommendations that you may now be aware of in light of the journey that we've been on, that you believe would enhance the life outcomes of people who have engaged in commercial loans with the bank going forward.
Certainly. Well, Senator, if I can address the first part of your question, namely, what is the Commonwealth Bank Group doing around culture? So in 2014, our CEO kicked off a process which we call our Vision and Values Dialogue. We have a vision across the group which is focused on enhancing and securing the financial well-being of customers, businesses and communities. And secondly, we have 5 core values. What we did in 2014 was engage the St James Ethics Centre here in Sydney, Dr Simon Longstaff, as well as KPMG and a law firm, to carry out across the group a series of focus group discussions and surveys in order to understand, were there any processes or procedures or policies across the group that actually inhibited an employee on a day-to-day basis from helping the bank achieve the vision and applying each of our values, which are integrity, collaboration, accountability, excellence and service. So we carried out those reviews, those focus groups and those surveys. With the results of those, we then prepared a report which went to be considered by the board and by the senior management. And what we did then is we embarked on a second part of the exercise, was then to identify policies and procedures and processes that our own employees had told us get in the way of us achieving the vision and applying the values consistently. What that has done is thrown up a range of items that we're addressing at the moment. So that work was carried out in 2015, following the initial work in 2014. So we have been addressing those policies and procedures to try to change them so that our employees are not in a position where they feel that their effort to, for example, ensure that a customer achieves financial well-being is stymied or hindered or delayed by one of our policies and processes. That's the first thing. It is an ongoing piece of work. We're an organisation of 52,000 people, and it is not possible to change everything overnight, but we are steadily working our way through it. The second thing that we have...
Before you go off to that, can I just ask, how is that integrated with your incentivisation structures and your financial reward for both individuals and teams, and how can the community be assured that matters of professional integrity, which I think are very, very at the forefront of people's thinking with regard, sadly, to Commonwealth Bank. What are you doing to make it happen, rather than, observations and talking about reporting, etc.? What are the incentives for people to behave in ways that meet community expectations?
So, it's a process that is embedded within our vision and values work. So, the issue that you raised is reflective of something that regulators have been saying too, and that is, are people rewarded not just for speaking up and for raising issues that are of concern, but are they also rewarded for demonstrating the right culture, the right values, the right ethics? And that is something that we're currently going through at the moment from July of this year, when we commence our new financial year. We're introducing a new performance management system and a new rating scale, so that people are actually measured not just on their business outcomes, which is part of our current process, but they're also measured on their application of the values. Because we recognise that it's not just what you do, it's how you do it. And the how you do it is more important than the what you do. So the new performance management system that is being rolled out across the group from the 1st of July is going to measure how each employee actually applies the values of the organisation, and the way they apply those values will reflect in their remuneration that they receive. So that's a very practical step that we're taking. Allied with that is something that we've alluded to earlier, which is we have a process whereby your risk behaviours, so the behaviours that each individual employee demonstrates when acting internally, dealing with customers, approving loans, taking actions, those risk measurements actually then get applied to alter the remuneration. So if somebody has not fully met their risk requirements, then that reduces their remuneration. If somebody has fully met their requirements, then they are free then to proceed to the level whereby they are assessed on their outcomes and the way they have applied values. So we are hopeful that that is actually going to be a very meaningful thing for people, that A, we're applying the values in everything we do and you get measured according to it. And secondly, your risk behaviours are then reflected and, are taken into account and reflect in your remuneration up or down, as do your values, the way you've demonstrated values. So we agree with you that remuneration is a very important factor in terms of behaviour and what behaviour it encourages, and that's why we've introduced a new system to take effect from July. To your second part of the question, Senator, if I can,
yes.
How can we enhance the sort of life outcomes for customers?
Yes.
That's a very good question. We seek, as I said before, we seek to achieve a vision whereby we enhance and secure the financial well-being of customers. We don't pretend that we're perfect at it. And you've alluded to situations where the media has highlighted and other areas have highlighted where we have not achieved that mark, and that is true. One of the measures of an organisation and whether it is seeking to do the right thing is how it responds to those situations, and I think in a couple of those situations we have taken a very earnest approach to try and rectify issues. Going forward in terms of how we deal with our customers to ensure that they do succeed in their endeavours, we will try to provide the excellence in customer service that we focus on so much, but applying our values, as I mentioned before, as well. The fact of the matter is, and this is an unfortunate fact of life, we know that some businesses will not succeed. In those circumstances, it's incumbent on us to work with customers, and we seek to do that, and we think we have demonstrated to you today and in our submissions that we do work with customers. It's not lip service. We actually do spend a long time working with customers. But unfortunately, there will be circumstances where success is not an outcome for the business, and we then have to work with the customer to try and achieve a resolution.
I suppose it goes again to Mr. Ruddock's point. If you know that there are going to be businesses where, or commercial loans in particular, but in a range of other interactions with your customers, there's going to be points of failure. Surely it would be prudent at this point, given what's preceded, to have established an independent resolution structure that would attend to some of the issues that have really taken up so much time in this committee hearing.
Well, Senators, I can repeat what I said before. I mean, that this is a very different situation in terms of scale and issues from issues such as storm financial or financial planning. And we honestly do believe that we have tried to address every single issue that has been raised, not just by this committee, but also by customers directly. And it is unfortunate, but we acknowledge some customers do not want to accept our version of events or the facts as we have presented them. I understand that.
And they don't have the money to take it to a court to find that resolution, and there is no other alternative. And I think that's the point at which we are today, which is frustrating for so many people.
Well, Senator, the facts are there for everybody, and we have always said, and we continue to say, that if a customer comes forward with either new information or evidence of mistreatment, that we are willing to sit down, we always have been willing, to sit down with customers and talk with them. We are willing to do that, and we have said we are willing to do that, and that remains the case.
What's the phone number to call?
If people wish to interrupt, I will ask you to leave, or I will suspend the hearing, Mr. Cohen.
That I have nothing further to say, Jim.
Mr. Ruddock.
Yeah, look, thank you very much for the copied letter. I don't intend to take it all up, but obviously Mr. Butler hasn't necessarily agreed with all of the points you've made. But I was interested in the point that was made that the head of your Legal Affairs Department is alleged to have said, "Sink boots into customer."
Yes.
And when I read the response, you don't deny it. You say more recently you've raised a specific allegation based on handwritten notes, I assume that's what was written, by a third party, that in September 12, Bankwest Head of Legal Affairs was that the new Bankwest should take an aggressive approach. So I suppose that's what sinking the boots in is, an aggressive approach to dealing with your situation. We have reviewed this situation and do not agree that Bankwest's Head of Legal sought to take an aggressive approach in your financial situation. In other words, by winding you up, appointing a receiver, we weren't taking an aggressive approach.
So in terms of having reviewed the notes of others that were involved in that meeting, that's fairly inconsistent with all the notes that I've reviewed from others. And as I stated in the letter, at that point in time, the head of legal was pursuing to actually have a meeting with Mr. Butler and mediate through the process and the matters.
That's not true.
Look, I just simply make the point. I've read what he wrote. I've read your response, and it just seems to me the issues are contested. And in my view, and I'll repeat it again, I think we need to... This committee's not going to be able to deal with those issues. And you know that, and we know that, but we're going to have to find a way forward. And I'm still inviting you to think through how that might best be done.
In the time being after the time allotted for the Commonwealth Bank, I thank you for attending the hearing and for your evidence today. You have agreed to take a number of questions on notice. Could you please return that information to the committee by the 12th of April? The committee will suspend until 3:50 when we'll return to the National Australia Bank. Thank you.